The primacy of European Union law is a legal principle establishing precedence of European Union law over conflicting national laws of EU member states. The principle was derived from an interpretation of the European Court of Justice, which ruled that European law has priority over any contravening national law, including the constitution of a member state itself. The majority of national courts have generally recognized and accepted this principle, except for the part where European law outranks a member state's constitution. As a result, national constitutional courts have also reserved the right to review the conformity of EU law with national constitutional law. For the European Court of Justice, national courts and public officials must disapply a national norm that is believed not to be compliant with the EU law. The United Kingdom claimed that statement to be contrary to the fundamental principle of the separation of powers into the national jurisdictions, since it provides to unelected courts or other non-jurisdictional charges the power to ignore the role of Parliament with a de facto immunity from law enforcement. Some countries provide that if national and EU law contradict, courts and public officials are required to suspend the application of the national law, bring the question to the National Constitutional Court and wait until its decision is made. If the norm has been declared to be constitutional, they are automatically obliged to apply the national law. That fact can theoretically create a contradiction between the National Constitutional Court and the European Court of Justice. In Costa v. NL, Mr. Costa was an Italian citizen opposed to the nationalization of energy companies. Because he had shares in a private corporation subsumed by the nationalized company NL, he refused to pay his electricity bill in protest. In the subsequent suit brought to Italian courts by NL, he argued that nationalization infringed a law on the state distorting the market. The Italian government believed that not to be an issue that even could be complained about by a private individual, since it was a decision to make by a national law. The ECJ ruled in favor of the government because the relevant treaty rule on an undistorted market was one on which the Commission alone could challenge the Italian government. As an individual, Mr. Costa had no standing to challenge the decision, because that treaty provision had no direct effect. But on the logically prior issue of Mr. Costa's ability to raise a point of law against a national government in legal proceeding before the courts in that member state, the ECJ disagreed with the Italian government. It ruled that law would not be effective if Mr. Costa could not challenge national law on the basis of its alleged incompatibility with law. It follows from all these observations that the law stemming from the treaty, an independent source of law, could not, because of its special and original nature, be overridden by domestic legal provisions, however framed, without being deprived of its character as community law and without the legal basis of the community itself being called into question. In other cases, state legislatures write the precedents of EU law into their constitutions. For example, the Constitution of Ireland contains this clause: no provision of this constitution invalidates laws enacted, acts done or measures adopted by the state which are necessitated by the obligations of membership of the European Union or of the communities. Article 1(6) of the European Constitution stated, "The Constitution and law adopted by the institutions of the Union in exercising competences conferred on it shall have primacy over the law of the member states." The proposed constitution was never ratified, after being rejected in referenda in France and the Netherlands in 2005. Its replacement, the Treaty of Lisbon, did not include the article on primacy but instead included the following declaration. 17. Declaration concerning primacy. The conference recalls that, in accordance with well-settled case law of the Court of Justice of the European Union, the treaties and the law adopted by the Union on the basis of the treaties have primacy over the law of member states, under the conditions laid down by the said case law. The conference also decided to attach as an annex to this final act the opinion of the Council. Legal service on the primacy of law is set out in 11197/07. Opinion of the Council Legal Service of the 22nd of June 2007. It results from the case law of the Court of just as that primacy of EU law is a cornerstone principle of Union law. According to the court, this principle is inherent to the specific nature of the European Community. At the time of the first judgment of this established case law, there was no mention of primacy in the treaty. It is still the case today. The fact that the principle of primacy will not be included in the future treaty shall